Hello, my name is Brian Mayer. I'm an attorney practicing in Southern California, and today I'm going to be answering the question of how to prove parental alienation in court. Now, if you're watching this video and you find it to be useful, please consider subscribing to my channel and liking the video because I do post videos like this from time to time. If you think this one is useful, you'll probably find some of my other videos to be useful as well. But on to parental alienation. The fact that you're watching this video means you probably know what parental alienation is. Quite simply, it is when one parent or caregiver makes an intentional effort to try to interfere with the relationship between the other parent and their shared child. Oftentimes this is just done out of malice, and it's oftentimes part of a campaign, a long-term sort of effort to interfere with that relationship. So when we're talking about parental alienation here, we're talking about that sort of campaign of effort to try to undermine and disrupt the relationship between the child and the other parent, and how do you prove that? Now, legally, it's significant when you can prove it. In every state in the United States and Canada and elsewhere, child custody is decided based upon the best interests of the child. And in some cases, like California, where I'm licensed, it's actually codified that the court shall consider the extent to which one parent interferes with the relationship between the child and the other parent when making its custody orders. But regardless of whether that's actually written into a specific statute or not, the fact is everywhere it's relevant if one parent is interfering with the relationship between the other parent and their child, because that interference goes to the core question of what's in the best interest of the child. And if you have a parent who's unjustifiably making that sort of interference, or who's simply doing it out of malice, then that is absolutely irrelevant to what the custody order needs to be to protect the child from that disruption. So proving it can be difficult, and I'm going to talk about some of the tools that we can use to prove it and some of the moving pieces. But I first just want to describe that body of proof generally as saying, I just want to describe it generally by comparing it to proving anything else in life. And people look at court and they see it as this mystic, sort of bizarre place with these strange rules and procedures that don't necessarily make sense. But ultimately, it all gets down to the same question of how can you show a judge who's a human being what's going on? And so you prove things in court just like you prove anything else in life. And how would you prove, for example, that you went to the grocery store today? Well, you might have a receipt from the grocery store. You might have specific knowledge of some of the sales going on in the grocery store. Perhaps there were people there who saw you and who would recognize you. You may very well have groceries in your house because you purchased them. Perhaps a police officer stopped you speeding outside the grocery store, which placed you in the vicinity, and you can just kind of put it all together and say, yes, I was at the grocery store, and you know this because A, B, C, D, E, F, and G. And the same is true with parental alienation. You can take the little pieces and put it together, but you need a theme. And you have to go into court with that theme of, I am being alienated, the other parent is responsible for it, and here's how you, the court, can know that it's happening. A, these text messages. B, this witness statement. C, this professional's opinion. So you have to have that theme, and everything has to relate back to that theme of, I am being alienated by the other parent. It is intentional, and here's how you can know. So when you're looking at this and you're watching this video and you're thinking about, oh, okay, well, how do I prove this? Well, first of all, you know it's true, so how do you know it's true? And start to take a look at things from there. Your own testimony is absolutely relevant and admissible, so if you have a personal experience dealing with the other parent, you can absolutely talk about that, but most people want something a little bit more concrete. And so that's what I'm going to talk about very specifically here. First of all, any written communications to the other parent that can be authenticated it can be absolutely gold. If you have something from the other parent who's saying, I never want you to see the child again, that's worth $1 million in court. They'll say, oh, I was just joking, or I just said this out of anger. Well, you know what? It ties in very nicely to your theme, and when you look at all the other pieces, you'll see how it goes. So absolutely any sort of text messages that clearly articulate a malicious intent to interfere with the relationship between the child and the other parent, absolutely you want that to be a part of your package, a part of your message. Secondly, as I mentioned, your own testimony, things you've observed and seen. Third, if there are any witnesses who are available who can also testify to things said by the other parent or caretaker, or who has observed sort of obstructionism, anything that's gone on that has basically made it more difficult for you to have a relationship with the child. You want to be able to bring those people in as witnesses. And especially if you're dealing with older kids, and if the kids have not been completely alienated from you and they can cooperate, then you may have to make the difficult decision to bring your children in to court, ask the court's permission to bring the children in to explain exactly what they've seen and what's gone on. So absolute witnesses are absolutely relevant. Another tool that I would recommend if you have the resources to do it, this is worth absolutely, it typically costs about $2,000, but it's worth $1 million, and that is to conduct a deposition of the other party. Now, a deposition is where you can sit the other party down. You can basically just grill them without a judge present. The questions that you ask don't even necessarily have to be particularly relevant to what's going on, but you can just sit them there as long as you absolutely need them. You can watch them squirm, contradict themselves. Most people, when they're dealing with lies, they can't keep their story straight. When they're engaged in misconduct, they make excuses that the more you get into them, they get weaker and weaker. And the advantage of a deposition is basically that it pretty much has, the limits are much wider than what you would face in a courtroom setting. You can double back to questions, you can ask them in any particular order. You just don't have a judge there who the other side can just raise objections to, and the judge just wants the day to be done and close out the case and can shut you down. So a deposition is absolutely a fantastic way to do that as well. The one option that I think is really fantastic that can really benefit, but it requires some skill on your part to make sure you're dealing with the right people, is to bring in a professional. Now, one option is to bring in an actual professional child custody evaluator. That can be hit or miss because although you're dealing with someone who's going to have at least a master's level, usually a PhD level training in child psychology and experience with these sorts of things, if they are not equipped with and familiar with parental alienation, then if they're just not familiar with it, if they can't pick up on it, then oftentimes they just don't come to the right conclusions. But if you can back up what you're saying and present it to that person, then a professional custody evaluator absolutely can be an ace in the hole for you. The costs for that are going to vary a lot. Usually you can expect to pay at least $5,000. It can go up to $15,000, so that can be out of reach for a lot of people. But another option that frankly can be just as good is to ask the court to have the court order the child to attend therapy sessions to deal specifically with the question of your relationship with the child and how it's impacting them. And the reason that can be so effective is because a therapist is really going to be a neutral party. They're not going to have a stake in the outcome. They are educated and experienced, and you basically at that point you've asked them to look at this issue and figure out what's going on, and they can usually very quickly figure out if the other parent is responsible for the disrupted relationship. But more importantly is that in this process, they're essentially, without necessarily even knowing it, going to be rooting for you for the relationship to mend and get back together, and they're basically going to be looking for ways to try to make that happen. So if you can make yourself available to the child, if you can make yourself available to the therapist, and the therapist is tasked with treating the question of how the child's dealing with your relationship with them. For that person, the solution is pretty much always going to be to try to work on that relationship between the child and the parent. And that can benefit you, first of all, toward your ultimate goal of having a good relationship again with the child. Secondly, it removes mom or dad as the savior, and just basically provides that sort of neutrality that that the court really needs to be able to discern what's going on in this case. And so that's, if you can, I strongly recommend asking the court that if the other parent doesn't agree to it, then basically ask the court to have a therapist assigned to the case. A court will pretty much never say no to a child receiving therapy when the parents are in a high conflict case, because let's face it, everybody needs therapy, especially kids in this situation. So it's a really good way to get just another person on your side. Some people will also recommend asking the court to appoint a guardian ad litem, also called a GAL. And the guardian ad litems are basically court-appointed counsel for the children. My opinion is that is risky unless you know who the attorney is going to be. The reason being that I've just seen too many cases where the attorney for the assigned to the children are just overworked. They're not really focused on what's going on, and they're just really not that much better in discerning between fact and fiction. So you're basically dealing with a neutral attorney, but they really don't have a whole lot of specialized training in dealing with kids or dealing with relationships. Usually they have some family law experience and maybe a few hours of a training class, and just that's it. And that just doesn't help them identify the issues going on that come up with parental alienation. Also, they tend to be really pretty expensive too. Usually you're looking at least a few $1,000s, and the court usually wants to pass that cost along to the parents. So I'm not going to say it's wrong for every situation, but being perfectly straightforward with you, if you want what's best for your situation, if you have the choice between a child custody evaluator, an expert child custody evaluator, a therapist, or an attorney assigned to the child, the best choice usually is the therapist first, the evaluator second, and the attorney for the child third, just in terms of the amount of control you can exercise in getting an outcome that truly is best for the child. So don't be intimidated by the process. Really focus on what you can do to just prove your case. You know what the facts are. You know the truth. You know it's somehow true. So how do you know? Just take that information, take that to the court, and then look at some of these tools. There are other tools of discovery that can be conducted, but these are the big ones. But consider some of those as available to you to just be able to prove what's going on. So again, if you found this useful, please consider subscribing to my channel. Check out some of my other videos. I do post them from time to time, and I hope that they're helpful. Definitely wish you the best of luck in watching this, and take care.